You're listening to Clearly Conspicuous, a podcast series brought to you by Holland & Knight's Consumer Protection Defense and Compliance Team. Here at Holland & Knight, we have the working knowledge of how federal and state agencies operate and how courts address consumer protection issues to effectively work with our clients to address these issues.
Good day and welcome to another podcast of Clearly Conspicuous. As we've noted in previous sessions, our goal in these podcasts is to make you succeed in this current environment that's very aggressive and regressive, make you aware of what's going on with the federal and state consumer protection agencies, and give you practical tips for success. It's a privilege to be with you today. Today we discuss actions by the U.S. Chamber of Commerce and others to sue the FTC concerning its rule to ban non-compete clauses in employment agreements. The U.S. Chamber of Commerce President and CEO Suzanne Clark issued the following statement immediately following the Federal Trade Commission's final vote to ban employer non-compete agreements. And as I read this quote, it really reflects the sentiment by other groups as well. Quote, the Federal Trade Commission decision to ban employer non-compete agreements across the economy is not only unlawful, but also a blatant power grab that will undermine American businesses and their ability to remain competitive. Since its inception over 100 years ago, the FTC has never been granted the constitutional and statutory authority to write its own competition rules. Non-compete agreements are either upheld or dismissed under well-established state laws governing their use. Yet, today, 3 unelected commissioners have unilaterally decided that they have the authority to declare what's a legitimate business decision and what's not by moving to ban non-compete agreements in all sectors of the economy. This decision sets a dangerous precedent for government micromanagement of business, and it can harm employers, workers, and our economy. The Chamber will sue the FTC to block this unnecessary and unlawful rule and put other agencies on notice that such overreach will not go unchecked. Close quote. Indeed, that's quite a mouthful, huh? Well, the next day, the Chamber of Commerce fulfilled its promise to sue the FTC, arguing in a lawsuit that the agency overstepped its authority. The lawsuit, filed in the U.S. District Court in Texas, argued that the FTC did not have the authority to issue rules that define unlawful methods of competition. The Chamber of Commerce was joined by 3 other business groups: the Business Roundtable, the Texas Association of Businesses, and the Longview Chamber of Commerce. Again, the suit came a day after the FTC announced a final rule to ban the non-compete agreements. The rule was approved in a 3-2 vote, with both Republican commissioners voting against the measure. Ryan LLC, a tax services firm in Dallas, also sued the FTC, generally raising similar arguments in a lawsuit filed in another U.S. District Court in Texas. Ryan is represented by Eugene Scalia, a partner at Gibson Dunn, who was the Secretary of Labor during the Trump administration. However, an FTC spokesman said in a statement that Congress empowered the agency to prevent unfair methods of competition, which it believes includes non-compete agreements. He said, quote, our legal system and authority is crystal clear, addressing non-competes that curtail Americans' economic freedom is at the very heart of our mandate, and we look forward to winning in court, close quote. So here's the key takeaway. Companies generally use non-competes to protect trade secrets and to avoid spending money to train employees who can hop over to a competitor. The FTC and worker advocates say that non-compete agreements suppress competition for labor, pushing down wages. The agency's rule was supported by unions, including the AFL-CIO and North America's building trade unions. Business groups opposing the rule included the Securities Industry and Financial Markets Association, a trade organization that represents Wall Street, and the American Trucking Association. Laura Patton, a lawyer at the National Employment Law Project, said a sympathetic Supreme Court had, quote, emboldened businesses to bring more challenges to agencies' power by arguing that every regulation should be explicitly ordered by Congress, which often deadlocks on legislation. Business groups are essentially asking not to be subject to any new requirements. What we've seen in this resurgence of corporations challenging the basic authority of administrative agencies to do their tasks. So please stay tuned to further programs as we identify and address these key issues and developments. I wish you continued success and a meaningful day. Thank you.
Thank you for listening to Clearly Conspicuous. For more information on our Consumer Protection Defense and Compliance team, visit hklaw.com/CPDC or email anthony.diresta@hklaw.com with any questions about today's episode.